Well, thank you so much for hosting us, and good afternoon, everyone. My name is Sonia Parras. I'm the Assistant Executive President and co-founder, and with me today are Cecilia Friedman, our Senior Policy Attorney. Hi, Cecilia.
Hello, good afternoon, good morning, everyone.
And Maria Lazarino, Program Associate. Hola, Maria.
Hi, everyone.
So today we are presenting this webinar thanks to a grant from the Office on Violence Against Women. And please remember that you can access Gail, Cecilia, or myself with questions at any time as an OVW grantee. You do not need to pay or be a member. You can just access our services and technical assistance by virtue of being an OVW grantee. So don't be shy. No question is a bad question, and we'll be glad to help you out if you are the legal representative of a survivor, or if you are a legal advocate helping to connect survivors with legal services and resources. You can also access our services and materials free of charge at www.asistahelp.org, ASISTAHEL.org. We're kind of in transition. We haven't transitioned just yet, but you're I encourage you to just go to our website and see the amount of information that we have for presentations, for clients, the latest updates, etc. So also if during our presentation your question was not answered, we're going to try our hardest, right? But if it's not answered, then we will make sure we get after the webinar. And we won't forget you because Maria's keeping track of everything that has not been answered. We thank you very much for joining us today and hope that you find this information useful to you that you help. So and with that, let's go into the goals. Today, we're going to be presenting information on bringing in family members living abroad and preparing the adjustment of a status application. And this is the first of two-part webinar. Next month, we'll be following up on some of the same topics, but we're going to step it up a notch and address those, harder issues that we may find. So even if you see our next webinar and you think, oh, I think it's kind of like the thing that we just did, or it sounds familiar, well, again, it's not. It's going to be at a higher level. We promise you that your time will be spent getting new information. So what we're going to do today is to identify potential qualifying relatives, surprise relatives as well, eligible for benefits at the time of adjustment. The next thing that we are going to cover are those annoying RFEs, the good ones and the bad ones, and the roadblocks as it relates to family members, so we can clean up the path and ensure that we can get to the end and to the adjustment of a status. And finally, at the end, I will give you a whole summary on how you can actually bring your clients' relatives and finally reunite your client with his kids or husband, right, by entering the United States via consular process. And with that, I'm going to let my colleagues to move on, but I just want to mention before we dive in that we have amazing materials. You can check all these resources that we have in here for you. If you're going to be doing lots of consular process, don't be concerned, don't be scared. It's not rocket science. You can make it happen. And there are really good guidance. If you are part of the SOHO database, you'll find the ins and outs and practitioners' tips, people going through the process in like real time, so you can help your client and you can warn your client of what to expect and how to get prepared. Super important if you're doing consular process that you go to the state.gov and you don't have to print it, you can download it, you can access it online at any time, the Foreign Affairs Manual, because that way you read and you know what the officers are being trained on and what DHS and the government is telling the immigration officers at the consular post that are going to be interviewing your client. So this is like really good heads up of what they have in their desk and how they're going to be applying all this, U visa laws, regulations, guidelines, guidance, etc. If you're like me and you like to learn by doing, but also by watching, you can go to the Immigration Legal Resource Center. They have wonderful videos on consular process, so you can feel very secure and safe about your first case. And with that, now for real, let's talk about eligible derivatives.
For real. Before we begin, hello everyone, this is Cecilia. And in going through this participant list today, I see a lot of familiar names and people who I know are really at the top of their game and experts in their field. I won't call individuals out, but I see you, and I know that you're amazing and have a lot of experience with this. So if there's something that, for example, we forget to mention or something that you think is an important point, please do participate in the chat. We want to make sure this is as dynamic as possible, given kind of the webinar format. But before we begin, there's an opportunity to raise your virtual hands. And how many people actually work on consular processing of cases? So if you could raise your virtual hands, we'll just give people a minute. Okay, so quite a few of you do. You see Maria, Norma, Monica, Jennifer, Shanti, right? Okay. Elizabeth, Payal, Marisa. All right, great. And then a lot of folks haven't. And I want to tell the folks who haven't that even though kind of consular processing, I mean, immigration law is complicated to begin with, and it changes all the time. And, to add another layer on to kind of what you already do might be seemingly very complicated. But as the folks with their hands raised can tell you, that it's something that is doable. It's something that is doable, and if you have the support with Asista or support of other people who are in your agency to kind of walk you through the process, it's something that you can already add into your existing practice. So if it seems just like another realm of space, don't let it intimidate you. It's something that is very easily folded into the work that you are already doing. But again, like filing things with the Immigration Service, it has its quirks, it has its process. And just like that, the affirmative process, consular processing also has its quirks and its little idiosyncrasies. And so you have more things to talk about as you're around the water cooler with consular processing. Before we begin, we're going to start things off with a hypo. We're going to talk about a U visa case. And we're going to talk about some family members that sometimes just show up. So let me read it, and I'll have you guys think about it. Your client, Sophia, has a 4-year U visa expiring in May, and you just filed for adjustment. She asked if you could help her other daughters. She misunderstood your question about children when you asked, because when you were filing the application, she thought that you meant only about the children who are in the United States. And now we learn that there's 2 more daughters abroad. Has this ever happened to anyone? You can raise your virtual hand again if there is these kind of surprise family members that you've picked up. Jennifer has, Teresa, Monique. Okay, so this is something that happens. Elizabeth, Carly, Issa, this is something that happens. This is not something that is way out of left field. So what we learn is that there's 2 additional daughters. Her daughter Anita will turn 19 this April, and a sub-A was never filed for her. And then her other daughter will turn 21 this May. And we also learned that the 21-year-old is about 6 months pregnant. Now, I want everyone to think about this and to write in the chat box what you think some options might be. And again, if you've never run into this situation before, don't worry about it. We're going to walk you through it. But for folks who do have some thoughts, please put them in the chat box. We'll just give folks a minute. And faith palm is definitely an option, but don't feel like that is not one when you learn that there are additional family members. Okay. So Issa suggests to delay the adjustment and renew the U. And then Kathleen suggests to file Sophia's adjustment before May, but ask that it be held in abeyance, and as soon as possible, file the supplement aids or file the stuff aids for the kids and request expedited. Meredith, thank you, Meredith, suggested a 929. We're going to talk about all of this in just a second. Jennifer suggests file 929 for Anita, or file the sub-A's for both daughters and file an extension for Sophia. All of these are really great suggestions, and we're going to wait for some other people to weigh in. And again, this is something that happens, and so this is also kind of a lesson in prevention. When we're doing our screenings, are we making sure that we're asking about all children in the home country and other countries in the United States, making sure that we are as thorough as possible in our initial intake so this doesn't come up later down the road. So as we wait for other suggestions, so some suggestions, there's some words being thrown out here. There's holding applications in abeyance and 929s and sub A's, and if this is, otherwise might be in French for you, or if you speak French, then that would be okay. But if this is in another language that you don't understand, we're going to go to the next slide, and we're going to talk a little bit about what this means. Oh, so now we're going to talk about derivatives. And so what do we know about derivatives? Who can be a derivative in the U visa context? If the applicant is over 21, then it's the spouse and minor children, as long as the kids are unmarried and under 21. And if the applicant is younger than 21, then it can be the spouse and the kids, the parents, and unmarried siblings under 18. And now what is important about and then in the context of 929, I-929s are available for what they call qualified family members. And qualified family members, and this is a process that is available once an individual already has U status, but a qualified family member was not included in the original application. So if the applicant is younger than 21 and has a U visa, you can file a 929 for spouse and kids and parents. Notice that we lose the sibling option, right? And then if the applicant is over 21, you can include spouses, even spouses that we call after acquired spouses, that if you were married after you had the U visa, and minor children. And so the thing we need to know, the very big distinction between this process, is that if we're talking about the supplement A's, then the age-out protections that was in VAWA 2013, that the age of the derivative is frozen at the time of the principal's application. That applies when we're talking about derivative U visa status. But in the context of 929s, it does not apply, and there is no age-out protection for derivatives. So what I want to do is I want to go back to our HIBO now. So there's a few things that I think that are key facts that we need to look at. And Maria and Sonia, don't think that you're just going to sit back and check your email now. We're going to ask you some questions. So we're looking at this, and we know a few things. And a few things that are important at this process is that we know that Sophia has filed for adjustment. And why is that fact important? Sonia?
Well, one could argue that once you actually have filed the application, then it is received, properly received by immigration, by Vermont Service Center, then it's considered as filed, and that shuts down the line of uh, people, family members that are abroad from continuing with the 918A application.
Okay. So if mom adjusts, and this is to everybody who is putting in the chat, if mom adjusts and becomes a green card holder, and can Anita and the other daughter, I don't know why we didn't name the other daughter, can they come in as U visa holders? Yes or no, people? Right, right. Jess is right, Stephanie's right, Christina's right, all you are right. You cannot come in with U visa status if the principal is already a green card holder. So this is really kind of a problem with timing.
Yep.
Right, so we're talking about holding, I think that Meredith or someone mentioned a process called holding a process in, Kathleen, holding it in abeyance. And so when you hold an adjustment application in abeyance, you say, okay, CIS, you need to not do anything in this case. I want you to hold it. Hold it until we maybe file sub-A's and get them filed. And the other part of this is not only do the derivative supplement A applications have to be filed, they also have to be approved, and they have to come into the United States before mom adjusts.
Mm-hmm.
So all of those three things need to happen in order not to cut off their eligibility to enter the country with U visa status. Now, this is important, especially because we have a daughter who's turning 21 in May. So the 918A, Supplement A, we do have those age-out protections. But before we talk about the pregnancy issue, I want to talk about the 929 part of it. And so the 929 is available, and it can be filed. Basically, the 929 essentially takes the place of the family petition. It kind of is like an I-130 for qualified family members. And so once the 929 is approved, then it's essentially the person can consular process it with their residency. So it kind of puts people further down the process. So if the daughters were 12 and 14, that's a very different situation because you're not running against this age-out issue, right? Because we have another process for the 929s that the daughter's going to turn 21 in May. And what are your concerns here, Sonia?
Well, if the daughter turns 21, she's no longer a child. Another thing that I want to know from mom immediately is, wow, she's 6 months pregnant. Did she get married? Right? Because the Immigration and Nationality Act defines a child as someone under 21 and unmarried.
Right. And so the other options we have too, is a timing issue. Can this other daughter have a 929 processed and filed and approved, and can she come into the United States, but we're in March, in 2 months? I think that this is very wishful thinking. The Vermont Service Center has said that they will expedite for age-out issues for 929. So if you let the Vermont Service Center know that you are running into an age-out issue, you can ask them to expedite, and if you don't get a good response, you let me know, and I'll see if I can help. So they will expedite in 929 for age-out issues. But I think, as Jennifer mentioned about, she says, can we withdraw the 485 and file an extension for Sophia? I would say that if she hadn't filed for adjustment, then filing an extension of U visa status would probably be a safer option. Because what we have seen happen is that the Vermont Service Center has proceeded with the application even though there has been a request for abeyance. The request for abeyance isn't a fail-safe. I think it's something that you have to be mindful of before you file for adjustment to make sure that you get all your derivatives in. But I think that if I were going it from the outset, that I might consider filing a 539 and having that be approved to allow for the derivatives to consular process in. Any other thoughts? Go ahead. Any other thoughts? Or people do anything differently?
The other thing that I wanted to mention is that if we look at Sophia's expiration date, is May 2017, and now it's March.
Yeah.
You know, so be very careful because maybe you're trying to grab onto as many as you can, and you're gonna lose, you know, the principle. So that is something also to consider. Whether you're trying to, you know, fix the other kids is going to leave mother without status, and therefore no one can adjust, right?
Yeah, so Madeline asked, what can you do if they don't honor a request to hold it in abeyance? Can you somehow like withdraw your application or something? And I have no good answer to that. But I think that you know, you could consider doing an I-130 once they have a residence and once they are an LPR, which would be its own separate process and its own separate wait time. So I think that's something you can do as an option once a person is a green card holder. And so that is something to take a look at. And again, ISTA mentions very good, like looking at your processing time applications, right? And are you looking, if you are doing the 539 extensions, what are those processing times like? How long is it going to take? But all this is to say is that in this situation, there are options. Life is easier for Anita because she has a few years. But when you're running against the age-out issue, you have to kind of engage whether or not you're going to do the 929 for the age-out protection. In this case, you might want to wait for everything to be held in abeyance and do the 918A because it does have that protection where the 929 does not. And also keep in mind that grandbabies are not derivatives. So in those situations, I know that folks in San Francisco have been successful with parole for babies of U3 or grandchildren. So now the question about what happens if the kids are in the United States, the only difference that we need to consider there is the entry, right? The kids need to come in before mom adjusts. And so, but also, and the same thing I think beyond that is that the youth status has to be granted to the derivatives before mom adjusts. Because if they don't, if mom adjusts and the kids don't have youth status, then that, and again, it could be different periods of continual presence because what the guidance that Sonia mentioned, and once I stop talking, I'll put it in the chat box as an actual resource, is that there's USCIS guidance that says that once U visas are filed, that their adjustments are treated independently, right? So everybody, like once everyone has that magical place where they have a full 4-year U visa, which is a good place to be in, once everybody has their full 4-year visas, the adjustments are treated independently. So mom could adjust, the kids could still be in U status, and there will not be a problem because they're treated independently once everybody has that full 4-year visa.
So, and Cecilia, before we move on, let me just read because I put it in the chat box, this memorandum that just kind of addresses everything. It's already in there for them. And it says,
stupendous. Do we have it as a PDF?
I just gave them the site, but I'm sure you have your magic technology ways of giving them the actual thing. So I'm going to just read these. I'm going to read this for everybody. So once a principal U non-immigrant is no longer a U non-immigrant, whether through adjustment of status to lawful permanent resident or through expiration of the U non-immigrant status, any derivative U non-immigrant will no longer be eligible for admission into the U.S. on a U visa. So I just want to give you a little, we're saying that even if you say, hey, please hold in abeyance, I've had situations where I've communicated with the hotline and then followed up, not just send an email and wait, just followed up saying, okay, here's my situation. I'm going to file the 485 in abeyance. I'm also filing a 539. And I know it's killing it, it's overkilling it, but I don't care. So just 485, I did not submit the medical records. They can't adjudicate a case without medical records. They can issue an RFE, give you 60 days for medical records, and even closer to, the case, what's going on and what's about to happen. And you can again remind them, I'm gonna give you the medicals, but I'm asking you to look at my 539 to let me bring the kids from abroad and not to issue this adjustment of a status, or else we'll cut off the kids. And again, I know Cecilia is wonderful in intervening and following up if your case is a heart attack kind of case, and that we can help. So some strategies, read the memo, and don't hesitate to ask and develop strategies that will ensure that we can help everyone.
All right. So I want to way back up my train. And so we talked a little bit about what 929 is. I mean, if you have never heard this before in your entire life, what we said before is that it's available for when the principal has U status, already is a legal permanent resident based on their U visa, or has an application pending, that there's an eligible family letter we saw before, and that you or your family member will suffer extreme hardship if not allowed to remain in the United States, and that there is discretion to be exercised in favor of the family member. I'm going to throw out a question to folks. Is there a 192 requirement for a 929 application? If there's EWI entry or any inadmissibility issues, do you file a 192? No, you don't. That's right, Jennifer. So the issue is that you do regular kind of waivers of inadmissibility are not available for 929. So basically what you have to do is to structure your application in the same way as if it were, kind of outlining the different equities in the case, the 929s and their approval, and the adjustment under 245M is discretionary. And so there's it's not a necessity for a waiver, a formal waiver of inadmissibility, but it is absolutely something that you should address. And now I'm going to turn it over to Maria because I think I stole her slide. Go ahead, Maria.
Okay. So as Cecilia was saying, the purpose of an I-929 is to request immigration benefits on behalf of a family member who never held the U non-immigrant status. In order to apply for the I-929, the principal U1 has to be a legal permanent resident based on the U1 visa or has the application for adjustment of status pending. The prior slide talk about who can be derivatives and no, and if you have questions, we can go back, but I think we covered that already. So the I-929, you will file the I-929 at the Vermont Service Center, and you need to include in the package the following documentation. Form T28 for both the applicant and the sponsor, the Form I-929, which is 7 pages long, and the last edition is from December 2016, and the prior editions are not accepted, so please use the new one. A $230 fee or a fee waiver request and supporting evidence, biographic information for both applicant and petitioner, and translation, proof of relationship for both, If the I-929 is based on a spouse, you will be also adding marriage certificates and divorces if applied. Proof of legal permanent resident status for the U1, including both sides of the LPR card or the I-485 receipt notice if the application is still pending. And you can file the I-929 if a family member is in the United States or abroad. So again, this is a good moment to ask the client if there is any other derivative abroad that were not included in the original I-918A U visa package. Also, you can file the I-929 if a family member is in removal proceedings. You need to demonstrate that your U1 will suffer extreme hardship if he or she is not allowed to remain in or to enter the United States. And you already know all about extreme hardship evidence, and as in the U visa, this is determined on a case-by-case basis, but you should include documentation including evidence of likelihood that the perpetrator's family, friends, or other acting on his or her behalf will harm the applicant or the applicant's children, about the applicant's need for social, medical, or mental or other supportive services that are not easily available in the home country, the evidence of the perpetrator's ability to travel to the home country and the lack of protection from the authorities in the survivor's home country. And again, our website has a section on extreme hardship where you can find documentation. You have also need to include evidence to establish that discretion should be exercised in favor of your qualifying relative member. You must include a personal declaration from both the applicant and the petitioner. And if we are talking about an I-29 for an spouse, you should include a paragraph about the good faith marriage, indicating how they meet each other, how long they were dating, if your family relative spouse was in removal proceedings. The standard of proof for the good marriage will be higher as in any immigration case. So include extra evidence that they were both living together in the past, any new kids from the relationship, support letter, etc. And as Cecilia was saying, there is no I-192 waiver for the I-929 application, but the Immigration Service will take into consideration all factors when reviewing the application, including any act that could make the family member inadmissible. So if you have any adverse facts, include positive equities. And for example, if your qualifying relative has any OWI conviction, you may want to include some evidence of going to AAA meetings or some evidence of rehabilitation, support letter indicating he or she is helping in the church and doing some volunteer services, etc. Let's move more. Important consideration, Cecilia covered already a lot of this, but just a few more things. I-929 is only available for those that never had U visa status. No age-out protection. The child must remain unmarried and under 21 until the I-929 is approved. And it's super important unmarried for all the application, because we found out that kids forgot about what means to be a kid, and they got married even if we say so. Please write a letter and do advices in writing for the kids to remain unmarried until the application is approved. No I-192 waiver on inadmissibility is required. What else? If you have a kid that will age out, including big red letters in the cover letter, emergency, please prioritize, kids will age out, follow up with a hotline as soon as you get a receipt notice or a notice of action, or follow up with a sister for an intervention so we can get your case approval faster, hopefully. You will need to include evidence about why the delay in the application, and the reasons may be passport, custody issue, medical reasons, etc. the I-929 will not be decided until the U1 adjustment is approved. And this is why it's super important also if you have some HR issues to include I-485 application completely from the very beginning. And let's see one more slide about some.
So can I ask a question, Maria? If we can go back just a second.
Go back to the slide? Yes, sure.
Yes. So what if a sub A was filed for a derivative abroad, right? It was filed and approved, but they never entered into the United States with U visa status. This is my question for everybody. Could you still potentially do a 929 for them, even though they did not enter, they have an approved sub A?
Any takers? Oh, Kathleen.
Yes. Yes. You can file the I-929 because they never had U visa if they did not enter the United States.
Right. So that is a very important point.
Yes.
What
Do
happens
you have to wait until your U visa expires, or can it happen at any time?
Can you repeat the question, Sonia?
Yes, this is from one of our the comments from participants.
Mm-hmm.
Do you have to wait to do the 929 until the U visa actually expires completely or not?
Until what expires completely?
The U visa.
The U.S.
No.
if you are abroad.
I'm going to say no. And this
No,
is
I mean,
why.
you're eligible for adjust once the 3 years of continuous physical presence.
Yeah.
So if folks are paying, we're paying attention to the clock, then we don't have to wait to the last hour to start this process. In fact, we shouldn't, because I think waiting causes trouble for everybody. And so I think beginning this process as soon as you can establish eligibility is really important. And I think again, we don't. Surprises are great on my birthday. Surprises are not good in my cases. And so I think that this is a situation, we don't mean to scare everybody, but this is just something that, when you're coming up against these time issues, it's just something to be aware of in the 929 process. And if you have any questions along the road, then we can definitely help you with it.
We have a question about how long does it take to process the I-929?
Well, I'm going to throw a question back to you. What does the 929 depend on?
It has to be first approved the adjustment of status for the U1.
Exactly.
So,
The 929s depend on the processing times of the U adjustment. Right?
yes.
And so what really is there, and I don't think, I'm trying to check as we speak, I don't think it's posted at the Vermont Service Center what the U-based 485s are. It says, actually it does, I'm sorry. It says that the 485s for U visas, right, are now at August 1st, 2016.
But like we tell our clients, do not rely on that date in the internet because they also get really savvy and they are going to harass you with, the website says this is the date, right? So it's important that you tell them give it or take a few months even, and it depends on the case as well, right?
Right. So what happens, so Bridget asked, what if the person ages out while they're waiting for the U1 to be approved? So what is very important is that VAWA 2013 says that the age of the derivative is frozen at the time of the principal's application. So there is protection at the U visa stage for age-out issues. And that is very important. That was a very important change because it was horrible for a very long time. But there's not for the 929, the qualifying family member process.
And
yes,
here's one and here's one thing that you can do to speed up a bit the process if you want to. And Cecilia, correct me if I'm wrong. You can, and Vermont will accept the 485, and as soon as you get the notice of receipt of the 485, you can file the 929.
Yeah.
Now, they are not going to adjudicate the 929 or get into that case until the 485 is actually granted. And when it's granted, they will turn their heads and their attention to that 929. I personally think it's a good idea to file that 929 as soon as possible once you get the 485 to save some time, and also arguably to present something to perhaps in the event of a detention by ICE that there is something pending, right?
Yeah.
Yeah. I mean, I think that it's always a better position to be in. But it is, yeah, and I think that we just need to, again, filing for adjustment when folks are eligible to do it and not waiting until, 2 months before expiration. And I think that just being mindful of time and doing things as soon as possible provides the most benefit.
Okay. So what we talk also about this, but what do we do if by the time the U1 needs to apply for adjustment, we have some new family relative as we were reviewing. So if the U1 is about to expire, the new qualifying relative is the spouse. What do we do in that case? So we file adjustment of status for the U1, and when we get the receipt notice, we can file the I-929 for the spouse. We have no problem in there. There is no age out issues, and there is no any problem. What if the qualifying relative is a minor close to age out, as they were the girls in the case scenario? So, as we say, the I-929 application does not contemplate age-out provisions. So, in that case, we can file the I-918 supplemental late for the derivative because of the age-out provisions apply on the U-Visa context, and the kid must be 21 and married at the time of filing. We can also we also have to file the U1, an extension, an I539 for the U1. And again, with big red letters, including in the cover letter, U1 is about to expire, age-out issues for derivative. Follow up with us, with a sister on the hotline so your case can be resolved. As Sonia was saying at the beginning also, the second option is to file an adjustment of status for the U1 that is about to expire with a hold in abeyance letter. And we would like to do the first option one, the I539, because it's safer, but sometimes there are no other options. If the qualifying relative is a minor, way under 21, well, we can do both strategies in here. We can file the adjustment of status for the U1 and then the I-929 for the derivative. Or we can file the I-918A for the new kid and the 539 for the U1. And as we also said at the beginning, if some of the kids is out of the game for whatever reason with the age out, there is also the possibility that when the U1 becomes an LPR, legal permanent resident, they do a family petition on the normal way with the I-130 and I-485 application. And we have a few more slides. This is about extension. For whom do you file and when an I-539 extension? You will file an I-539, which is application to extend status for any qualifying family member that needs an extension of the status beyond the expiration date of the principal U1 non-immigrant status. to make sure that the qualifying family member is able to attain at least the 3 years of continual physical presence in the United States in non-immigrant status to be able to apply for the adjustment of the status under the Section 245M. There are some cases where even if the kids are in the States, you need to file I539 because the U visa were approved later than the principal U1 approval date, and there is they cannot comply with the 3 years of continual physical presence in the United States. The Immigration Service may approve the extension for any reason that is consistent with the goals of the status, including but not limited to a situation where the family member is unable to enter the United States timely due to delays in consular processes. And if we are filing a 539 late when the U1, when the U visa is already expired, you may be excused if you can demonstrate at the time of filing that the delay on your application was due to extraordinary circumstances beyond your control. For example, the kid could not obtain the passport, could not enter the United States because the father did not authorize for minors. And the length of the delay was reasonable. You have not otherwise violated your status. You are still a bona fide non-immigrant, and you are not in removal proceedings. And the last delay of I539, the filing fee as of today is $370. Remember, you can always request a fee waiver by using Form I-912 and supporting evidence, or by submitting a letter proving evidence versus income versus expenses. You don't need to pay biometric fee for the I-539 in the U visa context. The I-539 was updated on December 2016. No prior editions are accepted. And you will file the I-539 always at the Vermont Service Center regardless of your geographical jurisdiction. In the package, you will include evidence of U.S. status for both principal and derivative, I-918, I-918A, approval letter, and including copies of I-94 cards. If the applicant did a consular process, you can get now the I-94 online. You need to include also evidence of adjustment of the status of the principal, if available, copy of both sides of a legal permanent resident card or the I-485 approval letter, evidence of relationship with the EU principal, birth certificates with translations, marriage certificates, divorces with translation if spouse. And a short statement from the applicant indicating why he or she needs an extension. This statement does not need to be a very long 5 pages personal declaration, just an statement, for example, saying, I applied for a U visa after my mom application. I need to extend the status to complying with the 3 years of continual presence in the United States with signature and date. Extension cannot be granted to derivatives that are outside the United States and never had a U visa status. And super important, the I-539 extension by itself will not grant a continuation of employment authorization. So if you have a derivative of a U1 who is already working and driving or both, you need to file an I-765 package and request an employment authorization using the same codes are you use for the U visa, A19 or A20, and the complete package for the I-765, fee waiver, pictures, or the money orders, and birth certificate and translation. Any questions? So I pass this to you, Ceci.
And this went really fast, but remember that we're going to revisit some of these like more in detail next month. So.
Mm-hmm. So I'm going to have people raise their virtual hands again. How many people have never received an RFE in their cases? Like never.
One.
Wow. We all have to learn ISCA's secret,
yeah,
because that is amazing. They have, it has clarified that she has responded to many, but she has not received one in her cases. Well, that makes me feel a little better. So we're going to talk about preventing problems, and we're going to talk a little bit about how to do what ISCA does and avoid RFEs altogether. And I think a lot of it is what we talked about at the outset is avoiding the surprise. But also making sure that we are mindful of our clocks that are running, right? We are mindful of our 6-month clock from the time we get our certification. We are mindful of how old people are when we are applying for the principal. We have what we need to get, if there's passports that need to be received or birth certificates that need to be translated, that if there's court dispositions that we need to get, if there's any disability issues, we need to make sure that we understand what it is that we're dealing with. If there is an interaction at the border, do we need to do a CDP or an OPIM FOIA? We need to understand the scope of all the potential problems that might arise. And so this is really important to be mindful and can give yourself a checklist. Are you putting notices in your calendars about when certifications expires, about how old people are? So I think it's really important to kind of prepare yourself at the outset about what the process is and what you need to file. Do we have everything that we need? So has anybody here been to a service center before? You can raise your virtual hands again. Has anyone ever been to a service center and taken a tour? All right, Jeff has, Dana, Maria. All right, so this is good because it gives you a literal sense of what it looks like. So picture like a big sort of, warehouse. And files are literally rubber banded together, okay? So you can get a sense of how they might lose your passport pictures or how they might lose your birth certificate because the system, is still very 20th century and it is rubber banded together. And so this is what we recommend in terms of, documents that might go missing. Something that we recommend in terms of a practice for prevention is that every derivative have his or her own index, and that all the documents that relate to the derivative are placed together. So not necessarily having here's everybody's passports or here's everybody's birth certificate. To do a packet, particularly for each individual, so that when everything gets rubber banded together, that we have every person has what he or she needs when Vermont is looking at their application, right? And so here's some kind of common issues that come up, and if you have others that you're seeing, we want to be able to talk about them. Something that is very common but is easily handled are those kind of missing documents. And so before, back when things weren't so insane at the Vermont Service Center, oftentimes you can say, hey, Vermont, I gave you that birth certificate. Like, why don't you look again? Like, see, in my cover letter, I said I gave it to you. But I would not rely on that process at all to be working, and that I think that it would just be easier to respond with the RFEs with the documentations that they said that they're looking for, even if you have submitted it prior. You can make a note in your cover letter that says, hey, I gave this to you already, but because the rubber band broke, here it is again. Don't say that. Oh my God, please don't say that. They're going to come back to me. They're going to get very upset. But just, I think it's easier, is my point, that it is easier just to respond if it's missing documents. Now, when we're talking about other issues that come up, if there's a particular criminal history, if there's multiple entries and exits, that is something that they want to see as that is often addressed in the context of RFEs. How many people have gotten RFEs for police reports where there hasn't necessarily been a conviction in the case? Has anyone been seeing this and asking for police reports? Okay, so Janie, Erica, this is something that I think is an emerging issue, and if you're seeing it, we can have a conversation about how to handle it. And I think that it is particularly problematic because police reports are, obviously, aren't subject to cross-examination. They are problematic in terms of due process. And so if you're seeing this come up in your cases, we want to hear from you and talk to you. Another issue that we see coming up is the issue of the certifier. If people are they're wanting to see that the certifying official has that certification authority. So have people been seeing that at all? Any kind of RFEs regarding certifier? Okay, so Stephanie has seen that. Kimberly, you've seen that. So these are some emerging trends, Jennifer. So these are some emerging trends that we have noticed in the context of the work that we do. So I think it's just important to keep us in the loop in terms if you are seeing trends in RFE, that it might be something that is a training issue or something that we need to highlight. As you're seeing something that more than once, we would like to see it. Again, remember when I talked about before, when you're dealing with the Vermont Service Center, you have your own subset of issues that you're used to working with and that you're used to seeing. And that is also true in the context of consular processing. And so, Sonia, you are definitely more of an expert at this than I am. What they oftentimes will come up is the proof of the relationship of the derivative and the principal, or if they identify other inadmissibility grounds that weren't mentioned on the 192. Sonia, do you want to speak into any more in terms of other kind of issues that you see in the...
Yes, a couple of tips, right, of things that we have been seeing through the technical assistance questions that Ceci and Gail and I do, but also through the cases that I'm handling. So Honduras and El Salvador are notorious for challenging the actual and real relationship between the person that, says I'm the principal and mother and the child. So because we are aware of this already, as we are preparing our case, we want to make sure that we send the kid with enough evidence the day of the interview so there is no doubt about this relation. So things like letters that the mom has been sending the kid, proof of money, wires that the mother has been sending whoever is in charge of the child. If there are any funky business with the birth certificate, please get it fixed before you send that kid to the consulate because they will not accept it. It will be challenged. They want to see originals. They want to see originals anymore of birth certificates, marriage certificates, and things of that nature. Pictures showing that, this kid and this mother at some point in time were together somewhere. Letters from grandma saying mom calls every Saturday, talks to kid, etc. So just to avoid a potential RFE, unfortunately, do the extra work now instead of later. Also, medical concerns. We have had, a lot of challenges with teenagers, because of their tattoos, because of drinking and doing marijuana. So it's very important that if you cannot have a direct conversation with the derivative, that mom is aware that this will become an issue and may be an issue. I'm advising my clients anymore to try to get tested for tuberculosis. TB is not very common. But if the kid gets a positive hit on a TB, you're going to have an additional 12 weeks of waiting time until that person is under treatment. So if there are any chance that the kid can go to the doctor and clear that out and do a test, if it is in the state, it's easier because, any city anymore for free will test for TB, but abroad it's a little bit more challenging. Make sure that, again, they don't show up with 1,000 tattoos, or they have an explanation for those tattoos. And if the tattoos look like any gang-related tattoo, that they explain why they chose the clown, as the tattoo, what they liked about the clown, why they're wearing the clown, because all these things, again, are going to be challenged at the interview, may delay the process. So you're all happy that everything done by you is great and good to go, and all the hard stuff with VSC is done, and yet you have to face the counseling.
And the other thing that I wanted to mention on the last slide that I didn't is that if you might get RFEs for fingerprints for the derivatives, and it's very important that you respond to the RFE in time. And even if that is the response to say, hey, we are having trouble scheduling the fingerprint appointment, we're working on it, that needs to be submitted to the Vermont Service Center with your RFE. And so it is very important that you respond to the RFE in time and in writing. When we went to the Vermont Service Center last fall, they said that a lot of people are just trying to submit their responses to RFE in the hotline, and that is insufficient, and that might result in a denial in your case. So make sure that you are responding to as thoroughly and sufficiently as you can in the time and according to the process that's outlined. Okay. And so, again, because we all want to be like IFCA and avoid our RFEs, an important part of doing that is to identify if there's any inconsistencies. And you have to look at those inconsistencies and say, is this going to be a problem or is it not going to be a problem? Is this a big deal or is this a little deal? And what do I mean by some kind of common inconsistencies? For example, if in the police report for a U visa, it says that, a person was, their shoulder was hurt because they were pushed, but it also doesn't mention anything about a sexual assault. And then your client and his declaration talks about a sexual assault. Well, why wasn't that mentioned in the police report? And there could be a very reasonable explanation for this, in terms of whether or not there was any language access issues, whether or not they felt comfortable talking about all of this stuff in front of a police officer. If a charging document says one thing, but the certification says another, that is more likely to be a bigger deal. And so I think it's very important to say, one, where are there inconsistencies in the record? Is it material? And if it's not material, you have to identify it, saying, what, the hospital report says it was her left arm, and, something says it was the right arm. We have to kind of think about, is that a material inconsistency? Is it? And if it isn't, you just say, this is why it's not. It's because this is a typo and it's later corrected in such and such document. Or say, if it is material, how do you best explain it? Do you need the declaration from the client to explain the circumstances? Do you need a statement from a medical professional or a therapist? And reach out for help. We are here to support each other. We are here as part of this community. And Assista is available to help walk through when you do have these more problematic inconsistencies, how are you going to address it? Because this is something that Vermont is very, very good at doing, is identifying, well, this is one thing. The charging document says that it is this crime, and you're now classifying it in the certification as something that's completely different. What types of things are you going to have to prepare at the outset to address these inconsistencies? Because it's important that you do it, because otherwise you're going to get that RFE, particularly if they are kind of bigger things like statutes not matching up. You're going to want to be able to explain that. And I think this is you, or is this Sonia? For biometrics? Yeah, I think we already talked about this.
Let me see. I can cover it. Let me flip the page in my notes. Okay, so just remember that you have to do biometrics, and that there's a difference between before 14 and after 14. So if your case is really close to turning, your kid is close to turning 14, just go ahead and ask for them and explain VSC why you're going to be needing to fingerprint the kid. So also get to know your consulate. Very few, and I haven't had the pleasure of working with them, very few are going to fingerprint ink your client, right? But most of them are just electronic. So make sure that you know that the card will be sent to Vermont Service Center and forwarded to them. And also that Vermont Service Center is going to run all their systems, FBI, etc. Um, so also, if you think you're not going to make it, Vermont Service Center works really well with you in terms of rescheduling the appointment or extending the time for the fingerprints. You be on top of it. Document that you're requesting an extension. The reason why you're requesting the extension normally is just because you can't find the kid, or there is no identification passport. They can make the trip because it's really long, etc. So try to explain why. And in our experience, Vermont Service Center is great at extending the period for fingerprint or even issuing more fingerprints. If your case is denied due to abandonment because you cannot or did not get the fingerprints on time, they're also really good about, motion to reopen case due to whatever humanitarian circumstances or extraordinary circumstances, explaining that client never intended to abandon the case, that this is what happened. We had a case once of a woman, I think, Maria, you work with me on this one, where the woman was, the kid was beaten up by the boyfriend and was not allowed to actually physically go, and she was kidnapped and retained in the house. So we were able to document that case was reopened without issues. So anyways, just things to consider. Don't give up. Don't give up, right?
Yep.
Do you want me to go on, Cecilia, or?
Sure, you're doing such a good job. You can talk about passport.
So passport validity, remember, that you have to have a passport that is at least 6 months. Be on top of it. One of the worst things that we deal with is kids without passport because of several reasons. So as you're opening the file, remember, like including your intake, if you wish, questions about passports, so you are foreseeing what kind of issues you're going to encounter down the road, because it's super stressful to be all ready to go and then, bummer, where is that passport? We don't have a passport. What do we do now about the passport? So start working on it from the beginning, because if you have time, you may be able to get that passport or something in lieu of the passport that may be good as well. So again, 6 months validity. You may be able to request waivers of the passport, and we will talk a lot more about that during the next month and more in depth. You can use like a special form to request the waiver of the passport. You can, we have had practitioners that have been successful in presenting the client to the port of entry with all the paperwork done, but not the passport, and that have been waived in. So there are strategies that you can try when you have no passport, right? So, and again, we'll cover more in depth the strategies on passport, but I just want to move on to the consular process, since there are so many of you that have not done this. You can't complain about resources. More resources. This is the Foreign Affairs Manual. This is like it should be like your Bible in terms of knowing what they're going to be doing at their end, so you prep your client accordingly. So having said that, I want to run super fast because it's 2:10. and I want to run super fast so I can cover at least the basics of consular process. So ready to go? All right. So you have to complete that DS-160, which is a pain in the bot because it has a lot of questions. If you need this, we can provide it for you. Maria can help me. We have the DS 160 questions in Spanish because we work a lot with Spanish-speaking clients, and we give it to the mom, and we try to get as much information before we sit down and do that electronic form. So when we sit down, we don't have to be like refreshing all the time and losing the information of the DS 160 because she doesn't remember. She's not quite sure. So it's paper, and I hate to create more paper, but it's helpful when you're like sitting down and filling up the information to have it in advance and to have the right information. Um, Things that I want to say about that. Well, we'll talk a little bit more about the DS in a second. So print that DS-160 is going to be super important. You have to make sure that your client is responsible enough that when you're done with your job and you have a package together, you give the stuff to your client so she overnights it or sends it in a carrier that is going to reach the derivative without any delays. And do follow up. We do a lot of babysitting in these cases, and just the nature of the case, make sure that the mom doesn't sit on the envelope, that is actually getting to the minor or the derivative on time, and then pay the visa application processing fee. You can do it if your client is not tech savvy, and get it done and get all that done for her. So just a way of reviewing. So once your I-918A is approved, what happens is that VSC is going to notify the appropriate agencies, including KCC, and there is going to be in the production information management system a record created that the consulate is going to be checking and making sure that, again, there are no fraud issues and that the application is coming from the correct service center or agency. And then once all that is done and checked and clear, they will forward it to the appropriate consulate. So this is a lot of blah, 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 and I love pictures and charts. So here is your chart, okay? So VSC approves the 918, 918A in this derivatives. Be very, very super careful in reading closely that approval notice. I don't know why. Sometimes we get 918As with the I-94 record at the bottom of the approval. We don't want that. That means that Vermont Service Center is thinking we're processing our kid in the country, and nothing is going to ever reach KCC and the consulate because Vermont Service Center is not going to send any cable, any notices to KCC. So we want to make sure that when we get that approval notice, right, the approval notice says at the top the correct information and all that, but check the bottom. And the bottom shouldn't have an I-94 because that is something that you will get later on via consular process, right? Okay, more things. So check the approval date on your 918A. Make sure that it hits the same expiration date as the principal. I don't know why Vermont Service Center sometimes messes up with those dates, and then we're all running and trying to amend. So from the get-go, make sure everything checks. More things. So then KCC gets notice, it's going to check against PIMS. You can also connect with them and say, hey, KCC, did you get my notice? Did you get my notice? Above all, if you're going to have to amend some records, I just pulled a case that I was working on where they issued the I-94, and this was June 14th. Then I have to, June 14, 2013, and they issued me the correct one in November 2013. So from June to November, I was sitting down waiting for them to do their thing and make the amendment because they made a mistake. So it doesn't mean that that's how long all the cases take, but just for you to have an idea. All right. So KCC creates a record on PIMS to be accessed by the consulate, and then we move forward. It is really fun. I don't know if it's not happening anymore that much, but in the old days when they were not that busy, KCC with a really funky accent, like southern accent, will call and say, hey, we got your approval, and we're just notifying you that we're sending your case to the consulate. The funny part was that sometimes we were getting KCC calls when our client was already in the country. So thanks for nothing, but but thank you for notifying me. So they were a little bit behind, and they're not calling that much anymore. But be aware that they may call your office to let you know that they got your case, that it has been forwarded to the consulate, etc. If you don't get, or if you're wrestling with whether or not KCC send the case to the consulate, or you're trying to make an appointment, they're telling you that there's nothing in there, you can also, once you get that approval notice, wait about a month or so, call the consulate and just confirm that they have that petition approval so you can continue with the case. I had a couple of cases, and Maria was with me on that, where for whatever reason the consulate took the application but were never notified by KCC, and then we were at a hold, waiting for them to actually make it happen. So, all right, so more charts and more steps. Moving on. So here's how you put once you're notified by KCC, you put together the DS-160. Again, we have those questions that we have in paper that we run through with our clients to make sure that we don't have glitches in the system and we lose all the information because it takes too long. Follow the instructions. If you have not done one yet, play with it. Do a mock one. Go to the Department of State and just play with the DS and try to try to get through all their sections and options, so you become more familiar with the web page. So once you are done with DS-160, the PIMS is confirmed, then you will move on to request an appointment. You can pay the visa from the U.S., and then the day that you go to the interview, make sure that you have all the forms that your client is going to be needing. Again, remember what...
Sonia, I'm sorry to interrupt you.
Sure.
So we are getting, saying, Bridget mentioned the last time she sent an email to pins@state.gov, they said that they wouldn't respond to that. Is that your experience lately?
Okay, so I haven't sent one lately, but there is also in the website a phone number for KCC, so you can also call them. You can call customer service, and find ways of getting them to reply. But they're pretty good about email normally. I'm not saying that Bridget was not hitting a rough patch. But we want to know also, Bridget, let us know if it's not going through, okay, and if it's not happening, okay?
Right, and the KCC stands for the Kentucky Consular Center. And PIMS is the Petitioner Information Management Service.
Right.
It's like a database.
Right. So one thing that I want to mention about the interview, and we will, I promise you, we will go more in detail, about on all of this next month. But one thing that I want to mention is to be very careful. Now, we have a lot of situations where the I-94 that is a stamp, the visa, the actual U visa that is printed and attached to the passport of the derivative has an automatic extension. Okay, and then people call us and say, Sonia or Cecilia or Gail, hey, the mom expires on May 17th. The kid just entered, but the consular has issued a visa until 2020, right? So am I good? And just a word of caution, because every time I have checked with every Vermont Service Center, and I have posed the question, they have said, we are the only ones that can extend and have jurisdiction and issue you visas. So don't take the word of the consulate, and just as soon as the kid comes in, file 539. Now you know about it. File that extension. Wait for the 3 years. Don't rely on that passport, I-94, or I'm sorry, U visa deadline, because again, that has been issued by the consular post and not by the Remote Service Center, right? So lots of good stuff. Okay, so let's jump now in consular process for the 929. So all of this information that I gave you were for U visas that were having their 918As approved, and we were trying to bring them back from abroad into the country, or bring them into the country for the first time. Consular process for 929 is pretty straightforward as well. There are a bunch of forms that I'm mentioning in there. You can see all the little steps. There are 4 steps. So um, there is a bit of a difference, because the 918A enters as a non-immigrant visa. Your 929 approval is going to come in as a lawful permanent resident. So the minute that 929 adjusts and goes to that consular post and it gets into the country, the passport is going to have already that I551 stamp, which is proof of lawful permanent residency. And once you get into the country, then you can actually request online the plastic card, because the person is already a lawful permanent resident, but the plastic card would be the proof of that, as well as the stamp, that 551 stamp in the actual passport of the applicant. So really quick, there is a series of forms. I just want to caution you that there has been a lot of changes, and that, for instance, the DS-230, I put it in there because there are some consulates that are super backwards and that are not yet caught up with the 21st century. So they're still using paper, but you're not gonna. I haven't done a DS-230 for a long time. Now everything is electronic, so you have your DS-260. The DS-2001 is you showing that you have complied with all the documents, that everything is prepared and ready for interview. The affidavit of support in these cases is an A64W. Those of you who do I-360 VAWA self-petitions know that we use that one. This is the same one that applies via consular process. Sometimes we get into fights with consulates about asking us for that A64. But remember that even though you don't have to show that affidavit of support, and that the principal can financially sponsor the beneficiary, you still have to file that form. Otherwise, your case will not go forward. Medical examinations have to be done. You have to understand what clinics are approved by the U.S. government in the country of origin, and your client can only go to those clinics to do the medical examination. Word of caution. Mexico is super easy to work with. El Salvador are a little bit hard to work with, because they keep coming up with, requirements that are nowhere. So you should call yourself that clinic and try to make the appointment and ask them way in advance. Tell me exactly what you want to see when my client shows up for the medical examination. And this is very important, because sometimes we schedule medical exams really close together with the actual interview. And if we don't provide enough time and something goes wrong with the medical examination, the person won't get the interview with a positive determination, and we'll have to wait and delay the process, right? I put in there all the fees that you're going to be using eventually, even when you come back to get that I-551. And I mean, the rest of the steps are pretty self-explanatory. If you're doing this for the first time and you're a little bit shaky and you don't know if you're doing it right, Ceci and I can help you out with this. And send you a table of contents or whatever you need as you're navigating for the first time these cases. More resources. So again, call us, tell us about your cases. We'll be glad to help you. Before again, if you're beginning, um, and we thank you very much for your participation. We have 5 minutes, Cecilia. We have 5 minutes left for questions.
Yeah, so people, thank you so much for joining us, everyone, and we would definitely be happy to answer questions from folks if you have them in the next couple minutes. Otherwise, we are definitely happy to continue this conversation offline, so that we can help you answer the questions, consular processing, or any other of the applications that you are filing for survivors. We just want to thank you for all the work that you do, and we're glad that you are partners with us. So we'll give folks another few minutes if they have questions.
Someone is typing.
Multiple attendees are typing, so let's see how many we can get in. Type really fast.
When file I-929 for a spouse, can third children be included? Yes, they can.
Oh yeah, absolutely. We're gonna see. Actually, our hypo is on. Some of our hypos are on this. Yes. So you will have to file 929s for each derivative, okay? Because they each have their own case. Yes. Okay, so once the 929 is approved, then you have to go through the motions of consular process. It's not an I-485. I see. If you're in the country, it would be, I'm still thinking consular. So, so it is, I don't know, Ceci, if you have polls on timing, but for us, we were very surprised. We received a group of cases that took about 4 months to get approved, and we about passed out. But normally they're taking us about 8 months, give it or take, close to a year. So, but again, we had a group of cases that they were approved in 4 months. Do you have any other answers for that one, Cecilia or Maria?
No, that sounds yeah, and if you think that, I think if you're running into any trouble in terms of getting a response from the hotline, definitely let me know, and I'm happy to help clarify it. Do we find the same challenges for consular processing for VAWA derivatives as for you visa holders, Sonia?
So I think consulars are doing more use than VAWA anymore. So VAWAs are a little bit tricky because remember that if you're doing a VAWA, you have to deal with that I-824 notice of action on approved petition. So there is an extra step. So it may take a little bit longer inside of the country, but once everything is set and ready to go to the consular, what they will be looking at is inadmissibility issues. So, don't get too comfortable because for U visas, most of the stuff they're waived. If you ask for it, they're waived. For VAWA, they're still held to a bit of a higher standard when it comes to inadmissibility issues. And I'll be glad to help you or discuss your VAWA consular if you have one now. So if you think your case is outside of processing time, because for instance, just say
so
I is over a year, follow up with the hotline and just say, in the subject line, say 45 outside of processing time. Now make sure that it's indeed outside of processing time, and they're really really good about getting back. And most of the times, the email that you're gonna get back is, "We got you. We know it's being worked on." But at the same time, if something has been missing or they forgot or misplaced, or they're going to track it down and then they're going to get back to that case.
So, Jennifer, I'm sorry I am being kind of gratuitous with your my answer. But what they said was, so if you don't hear back on the 929 within 60 days of the principal's adjustment approval, to let them know. Okay? And so then you start emailing the hotline, I think after 60 days if you don't hear anything back after the principal's adjustment. And then if you don't get a useful answer, you're talking about the 45 based on that approval. I don't think that it would be under the same processing timeline, but Jennifer, I will ask. I will ask, and so we can circle back offline, and I will see if we can kind of get a sense of what that processing time is.
And Jennifer, I thought you were talking about that 485, not the 929. So yeah.
Right, but that is that's different, and that is not particularly
Absolutely.
listed.
Absolutely.
But I will ask.
All right, so we're at 2:31. So we really appreciate all of your questions. Again, keep up the good work. We hope to see you or hear you next month. And thank you so much, Cecilia and Maria, as well.
Oh, thank you to you both.